Hello, today we will be discussing construction liens. First, suppose you take your car to a mechanic and he repairs your car for $3,000. If you do not pay him, he will not give you your car back. It's pretty simple. When dealing with repairing a building or constructing a building, it's not that easy. That's why we have this concept of liens. It provides some protection for the contractor in case the property owner doesn't pay. Today I will cover these key concepts. So if you're ready, let's begin. A construction lien, also known as a mechanic's lien, is a legal claim placed on a property by a contractor, a supplier, or other party who has provided labor or materials for the property but has not been paid for the services. Liens are not used for government property. We will cover those projects in another video. Liens can be filed against both commercial and residential properties. They serve as a way for those who have performed the work on property to secure payment for those services. The process of filing a lien typically involves serving a notice of lien to the property owner and potentially recording the lien with the local government. Once a lien has been recorded, it becomes a matter of public record and can impact the ability of the property owner to sell or refinance the property until the lien has been resolved. If a contractor actually files a lien, the relationship between the contractor and the property owner have become strained. This is not a good situation. Liens can also impact the ability of other contractors or suppliers to be paid for their work on the property, as the property owner may be required to pay off any outstanding liens before releasing payment. It is important for contractors, suppliers, and other parties who perform work on the property to understand their rights and responsibilities with regards to liens. They should also understand the proper procedures for filing and releasing a lien, as failure to follow the correct procedures can result in the lien being deemed invalid. Now let's talk about lien waivers. A lien waiver is a legal document that is used in the construction industry to waive the right to file a lien against the property. The purpose of a lien waiver is to provide assurance to the property owner that all parties who performed work on the property have been paid in full and will not be filing a lien against the property. There are two main types of lien waivers: conditional and unconditional. A conditional lien waiver typically states that the waiver is contingent upon receipt of payment, while an unconditional lien waiver fully releases the rights to file a lien against the property. It is important for contractors and other parties who perform work on the property to understand the implications of signing a lien waiver, as once a lien waiver has been signed, the right to file a lien against the property cannot be reinstated. In addition, it's important to ensure that the waiver is legally binding and complies with state and local laws, as well as any industry-specific requirements. Lien waivers are often used in construction projects as a way to reduce risk and improve the flow of payment between the parties. By exchanging lien waivers, the property owner can be assured that they will not face a lien on their property, while contractors and suppliers can be assured that they will receive payment for their services. The timing requirements for filing a construction lien vary depending upon the jurisdiction, but there are generally deadlines within which a lien must be filed in order to be valid. In most states, the deadline for filing a lien is usually between 90 days and 180 days after the last day of work performed on the property. This deadline is known as the statute of limitations, and if a lien is not filed within this time frame, the right to file a lien may be lost. Additionally, there may be pre-lien notice requirements in some states, which require the contractor or other party to provide written notice to the property owner before the lien is filed. This notice is designed to provide the property owner with an opportunity to resolve the payment dispute before the lien is filed. It is important for contractors and other parties who perform work on a property to understand the specific timing requirements for filing a lien in their jurisdiction and to ensure that they follow the correct procedures to secure their rights. Failure to comply with the applicable timing requirements can result in the lien being deemed invalid. It's important to note that there may be other requirements and deadlines that must be met in order to preserve the right to file a lien, such as the need to send a notice of lien to the property owner or to record the lien with the local government. Now let's talk about the flow of the liens. This is the textbook case. In this first scenario, there's a contractor and a property owner. The contractor performs the work, then the contractor sends an invoice to the property owner. The owner pays the invoice. The contractor provides a lien waiver for the work for which the payment was just received, and this cycle repeats until the end of the job. In this next scenario, there's a contractor, a subcontractor, and the property owner. The subcontractor performs work, then the subcontractor sends an invoice to the general contractor. The general contractor sends an invoice to the property owner. The property owner sends a payment to the general contractor. Then the general contractor sends a payment to the subcontractor. The subcontractor provides a lien waiver to the general contractor for the work for which payment was just received. Then the general contractor provides lien waivers to the property owner for the work for which the payment was just received. And this cycle repeats until the end of the job. So that's the textbook case. Now in real life, the flow might be a little different. In this first scenario, there's the one contractor and the property owner. The contractor performs work. Then the contractor sends an invoice to the property owner with a lien waiver. Now this lien waiver may be conditioned upon the payment, or the lien waiver may be non-conditional. The property owner sends a payment to the general contractor. If the lien waiver was conditional, then this payment will satisfy the condition. Sometimes a non-conditional lien waiver is still required after the payment was made. And then this cycle repeats until the end of the job. In this next scenario, you have contractors, subcontractor, and the property owner. The subcontractor performs the work. Then the subcontractor sends an invoice to the general contractor with a lien waiver. Now this lien waiver may be conditioned upon the payment, or this lien waiver may be non-conditional. General contractor then sends the invoice to the property owner with the lien waivers. Property owner then sends payment to the general contractor, and the general contractor sends payment to the subcontractor. If the lien waiver was conditional, then this payment will satisfy the condition. Sometimes, again, a non-conditional lien waiver is required after the payment was made. Then this whole cycle repeats until the end of the job. Here are some problems that can arise. The payments can take longer than a billing cycle, which means that more than one invoice might be outstanding at a time. This could pose a risk to the contractor that they might be waiving rights even though they're not getting paid. And that's something that they have to think about. Sometimes the language in a lien waiver may be non-conditional even though the actual payment has not been made. The contractor needs to evaluate their relationship with the other parties, and if it's a strong enough relationship, they should be comfortable with moving forward, even though it's a non-conditional lien waiver. Sometimes the language in the lien waiver may require signing away rights beyond simple lien rights, such as waiving rights to any and all other claims, including claims of change orders. During the contract negotiation phase, it's important to look over the language that is in the lien waiver to make sure that you are not forced to sign away any rights that you don't believe are necessary or relevant. In some states, a third-party contractor or subcontractor who wishes to secure their lien rights must serve a notice of intent to the property owner before starting the work, or within a certain number of days of starting the work, such as within 30 days of starting the work. The notice must be sent via certified mail, return receipt requested, or personally delivered to the owner or the property, to the owner of the property or their authorized agent. Failure to serve the notice timely can result in the loss of lien rights. It is important for contractors and subcontractors to comply with these requirements to protect their lien rights in their state. Often when a third-tier sub serves notice near the start of the job, property owners and sometimes general contractors are confused and upset about this. This generally is a result of a misunderstanding about what this notification actually means. It's just that party's way of saying, "Hey, I am on your job site. Don't forget that I need paid." It is not saying they will actually file a lien. They're just trying to secure their rights. Well, that's all for today. I hope you found this valuable. If so, please consider subscribing to this channel, and I will see you on the next one.